Okay, so we are again for the second part of the section on the Constitution and the founding of the American Republic. So I'd like to finish up talking about what I was going over last class. Obviously, getting through the second part of the Constitution. Talk about the Federalist Papers a little bit, and then also talk about this New York Times article, another stab at the Constitution, which I'll kind of go back and forth to, since basically they are a series of short articles, basically giving people's ideas for what they would do to potentially fix the Constitution, and I'll address that. I think some of the contributions are pretty good. I think there are some things that are being left out of that. So let me get to it. I like to get through this as fast as I can. So I believe I left off here, just starting to talk about the executive branch of government, which of course is covered in the second article. And of course, I'm not going to go through word for word the Constitution that closely. Obviously, everyone already has access to read it, and it's not a hard document to read. It's not very long either. I would like to just sort of outline what I consider, of course, to be some of the more important aspects of that. And of course, when you're talking about the presidency, you're talking about the Electoral College, this very strange system that we have, which is sort of unique, right? As again, one of the contributors to the Times article states, Alexander Kezar, or Khazar, I believe is how you say it. No other country has really imitated that aspect of our political system, and I think for good reason, as he says as well, in that it's not a particularly good system. First of all, basically what it does is that it essentially does not allow for the citizens of the country to actually vote for the president. At best, it's an indirect vote. You vote for electors within the state who then cast their vote for the president. But even as the system was originally designed, it didn't even do that. Originally, as the system was set up, the electors would be chosen by the state legislatures, and they would choose the electors for the state. Now, as it happens, the system gradually evolves in the sense that people do cast votes in the state, but it's still not a good system, because essentially what it does is that it creates a lot of wasted votes, and that's why you have situations that occur where a presidential candidate, as we've seen, can lose the popular vote and then go on to win the Electoral College. It's because what happens is that when you're voting for the president, you're basically voting in a statewide election, not a national election. If you voted simply in a national election, whoever got the most votes wins. That would be, a much more rational system. What you do, though, is that you vote within your state. And in theory, all you need to do to win the electors for the state, at least for most states, that are sort of have all or nothing rules that give, all the electors, all the electoral votes to that state with the candidate with the most votes, is that, in theory, all you have to have is maybe like one more vote. And of course that never happens. But what does happen, though, is that you ordinarily have a sort of an excess of votes. You have many more votes cast for the candidate in that state that simply don't get counted at all. And because the system tends to waste votes, that's essentially how you have this outcome where the candidate can lose the popular vote and then go on to win the electoral vote. So again, an obvious fix to that would be to get rid of the Electoral College and just have a straight up nationwide vote. But I don't think that's going to happen. In the discussion board and in the assignments that people have been posting, I notice a lot of people emphasize that we have this amendments process, that the Constitution is a living document and things like that. And that is true in theory. The problem with that, though, is that it's almost impossible to get any constitutional amendments passed, especially now. I mean, yes, the Constitution has been amended, 27 times in its past, first 10 being the Bill of Rights, 17 times, subsequent to that. That's not a whole lot, given the whole history of the country. And again, most of those amendments obviously came from, a sort of bygone era. I mean, to get the Constitution changed today, you would need, again, 2/3 of both the House and Senate, as well as 3/4 of the states. That is, basically like 38 states you would need to vote on a constitutional amendment. I just don't see that happening. Given the level of division within the country, given that, it's very hard to imagine 38 states coming together to vote on something. So we're pretty much stuck with this system, and as it is not a particularly good system for electing the president. Now, of course, Article 2 also covers the president and the vice president. That role was not even clearly defined. In fact, one of the early post Bill of Rights amendments, the 12th Amendment, does sort of specify that relationship a little bit more. The other thing, of course, that is talked about is the impeachment process, which is that basically gives the Congress the power to impeach the president, which we've have seen a handful of times, more recently, of course, with Trump. And again, I mean, that is an interesting process. No president has ever successfully been removed from office. If you count Trump twice, 4 presidents have been impeached throughout, or there've been 4 impeachments of presidents throughout history, 2 for Trump, and then for Bill Clinton, and for Andrew Johnson after the Civil War. Anyway, I won't get too much into that, but let's look a little bit more at this idea of the Electoral College. So this is something. This is from a right-wing news website called the Patriot Post, where I looked them up before class. Apparently, the editors and the writers of this esteemed publication published their favorite firearm on their website. What kind of gun and ammo they prefer to use. So they're very patriotic people, I guess. Anyway, and I've seen this graph reproduced elsewhere as well. What they're doing basically is sort of gloating over the fact, or bragging, that the Electoral College is an extremely undemocratic institution. And again, as it says here, the states in blue have a smaller population than LA County, which you can see highlighted there in red. The Electoral College ensures that they have the same voice as the coastal elites. Now, this whole framing of this argument is absurd, right? I mean, this is presumed, this is this kind of, phony, faux populism that you see so often among the right wing. They're pretending that somehow the Electoral College, protects the common person or whatever from the tyranny of the elites. But of course, there's a major problem with that argument, right? I mean, obviously, not everybody who lives on the coast are part of the elite, but that's literally what they're implying here. So all the people that live in New York City, all the cab drivers and baristas and all the other people, the store clerks and things like that, they're all part of the elite, apparently. And the same goes for the West Coast as well. Obviously, that's a very facile argument and it's quite absurd. But this is again how they try to justify it. The reality is of course that the right in this country knows that they don't really have the numbers to win elections anymore, and so they have to increasingly rely on undemocratic institutions such as this. I mean, the fact that the 2 most recent Republican presidents basically came into office, losing the popular vote, I think kind of speaks to that. As do other things, which we'll talk about, later on in the class, like the issue of gerrymandering in the House and the filibuster in the Senate and things like that. The widespread attempt at voter suppression that you see in many, again, Republican-controlled states, all speaks to that idea as well. The right wing in this country knows they don't really have a true popular majority anymore, and so increasingly have to rely on these methods in order to stay in office or to win elections. And I think it's a very, dangerous thing because, the idea that you are somewhat accountable to the majority of people, I think does serve as a restraint on what people in power will do. When you take that away, I mean, it doesn't stop people, it then doesn't stop, in this case, the Republican Party from instituting laws which are very, harmful, which do, serious, harm to people within this country, to large numbers of people in this country at least, and they simply don't care because they no longer, have that restraining influence of, the majority of voters anymore, that they actually have to, to some extent actually like cater to and try to win over, a majority of supporters on their side. Instead, it frees them up to basically, play to a very vocal minority of people that have views that are, very much, opposed to what the majority think. So this is an excerpt from the Supreme Court case, Bush v. Gore. And of course, this is a very, controversial Supreme Court case. I mean, it's kind of downplayed now, I guess, in history. It was something, as I've mentioned before, I think played a big influence, had a strong influence on, Wolin's critique of the media, not just playing, cheerleaders for the invasion of Iraq, but also, the fact that the media tended to downplay the blatant, theft of the election during Bush v. Gore. And this is a sample of that, which is believed to have been written by Scalia, the late Supreme Court, conservative Supreme Court judge, who specifies, or who writes here, that the individual citizen has no federal constitutional right to vote for electors for the president of the United States unless and until the state legislation chooses a statewide election as the means to implement its power to appoint members of the Electoral College. I'll skim through some of this. This is the source for the statement in McPherson v. Blacker, that the state legislature's power to select the manner for appointing electors is plenary. It may, if it so chooses, select the electors itself, which indeed was the manner used by state legislatures in several states for many years after the framing of our Constitution. So basically what he's saying here, and this inclusion within the Supreme Court case, I mean, obviously is instructive in that regard. And then basically what they're saying is that, you don't really have the right to vote for president of the United States. So in the context of Bush v. Gore, this controversial issue over the recount in Florida, I think what they're, suggesting here is that, basically, why go to such lengths to do this recount? And I don't want to litigate Bush v. Gore. If you don't know about it, you should read about it. There are a lot of facets to the debate, but essentially, I think it's quite clear that the Supreme Court kind of exceeded its authority here. That the conservatives on the Supreme Court, basically stole the election for Bush. I mean, the fact that Scalia and Clarence Thomas apparently had family members working for the Bush campaign says a lot, I think. That the state, the Secretary of State for Florida, who's sort of, in charge of overseeing the elections, Katherine Harris, was also working for the Bush campaign. That Bush's brother was governor of the state at the time. All those things, cast doubt on that. But essentially the idea is that there was a recount going on because the results of the election were too close to call. It seemed that it was sort of going in favor of Al Gore, and the Supreme Court first stopped the recount, and then basically said, "Well, now it's too late to do a recount, so we have to go by the original decision." And they used a very kind of Orwellian sort of twisted logic that they were actually protecting the democratic process by doing this, even though what they were essentially doing was, awarding an election to Bush without counting all the votes. And it's almost, I think universally agreed upon now that had the recount gone through, that it would have, ruled in favor, that the recount would have gone in favor of Gore. So what, I mean, so in other words, what I'm saying is that the election in 2000 is the worst election in American history. I mean, it's the most illegitimate election in American history. It's far worse than the fact that Bush lost the popular vote, which he did, even awarding the state of Florida to him. He still lost the popular vote. But what happened, it was something much worse than that. And the fact that they basically, capitalized on the incapacity, basically, of the state of Florida to carry out a recount properly. They simply, lack the proper means to do this in an organized way. And their sort of lack of organization and incompetence, quite frankly, created enough of a sort of loophole, or created enough of a sort of, a gray zone or ambiguity that it essentially, allowed the Bush people to basically steal the election. But again, I mean, keep that in mind, right? The Constitution does not actually give people the right to vote. It doesn't say anywhere, in fact, that all citizens have the right to vote. It prohibits taking away the right to vote in some of the constitutional amendments based on race and gender and things like that. But there is no sort of like positive affirmative language where it actually says, yeah, all citizens have the right to vote. In general, or again, in this case, specifically for the president of the United States. So I think that's certainly important. Again, Kazar points this out. I think, probably one of the better contributions to the New York Times article. Certainly one of the ones I agree upon the most. I don't think I've skipped any yet, other than Randy Barnett's contribution, who was in favor of amending the Commerce Clause, which is actually found in Article 1 of the Constitution. I don't really have a lot to say about that. What the Commerce Clause does basically is give Congress the ability to regulate interstate commerce, basically, business that crosses state boundaries. Barnett feels that gives too much power to the Congress. Okay, but I mean, it's very rare anywhere to find, any kind of commercial activity that purely happens within state lines anymore, right? Given the prevalence of large corporations and things like that obviously clearly not only operate across state lines, but operate across national boundaries as well. So that's one of the contributions. I don't really particularly have much to say about that. I don't think all the contributions are equal. I think some are more important than the others. I think the idea that we should get rid of the Electoral College is a very good idea. And it's a very easy fix as well. You simply just go to a nationwide election. The problem with that, it would be very hard to accomplish in terms of politics now, given the way the amendment process works. Which incidentally, the amendment process is the focus of another contribution here, which I'll get to in a moment. But anyway, so moving on, we now get to Article 3, the judicial branch. And here again, here we have the establishment of the Supreme Court, the lesser federal courts, which I think is important distinction here. I believe this is linked to the website, which I won't click on. Will sort of show you, kind of the breakdown of the lesser courts. Most of the time when we talk about, obviously, the federal judicial branch, we normally mean the Supreme Court. But there are courts, there are federal courts that exist underneath it as well, including there are 13 appeals courts. There are, I think 94 federal district courts spread out throughout the country, and there are other courts as well, like the FISC court, the Foreign Intelligence Surveillance Court, which basically rubber stamps all the government's spying operations, which were exposed by Snowden and by people like that, and a few others as well, which, for the most part, I'm not going to focus on. Obviously, the Supreme Court is the most important. One of the things which is important to keep in mind here is that the power of judicial review, the power of the court to essentially strike down laws or actions taken by the government as being unconstitutional, is not actually found within the Constitution. This was a power that was sort of came about through an early Supreme Court case known as Marbury v. Madison, which we'll turn to later on, which we'll look at maybe a little bit more later on in the class. The basis for it, the circumstances of the case, of course, are fairly complicated, but the sort of legal rationale for it, I think, is fairly simple. Marshall, the Chief Justice of the Supreme Court, argued that if the Constitution is the supreme law of the land, which it does say in the Constitution, then any law or action taken by the government which contradicts the Constitution must, by virtue of that, be invalid and thus unconstitutional, as the phrase has come to be known. Again, I mean, you can see the logic in that. I suppose, as far as the way in which this power has been used throughout time is a bit more controversial, which we'll examine again. But again, I mean, just keep in mind for now that that power, which obviously gives the Supreme Court tremendous power over the other branches of government, is not actually in the Constitution. There's also a distinction between original jurisdiction and appellate jurisdiction in the court. The notion of original jurisdiction, meaning cases that come directly in front of the Supreme Court without going through other courts first, fairly rare. There are some instances specified here, but it's a pretty rare phenomenon. The cases come directly to the Supreme Court. Most of the cases, the important landmark Supreme Court cases that we talk about are heard by the court on appeal, meaning that they go through lower courts first before ending up at the Supreme Court. Usually, in many cases, at least once, but sometimes maybe even two or three times, where they go through state courts and then lower level federal courts before arriving at the Supreme Court. And that again means that, of course, that these other courts have already ruled on these things, but people are allowed to or organizations are allowed to appeal these decisions and sometimes make it up to the Supreme Court. Now, the Supreme Court does not have to hear every case that comes before it either. I think in a given year they only hear about 100 cases a year out of thousands probably that are that people petition the court to hear. So only a very small amount of them actually end up getting heard by the Supreme Court. Now, again, going back to the to the New York Times article, the leadoff article actually is the piece by Jamal Green, who argues for term limits for judges, another controversial issue. And what Green says is that basically Supreme Court judges, and again, this would be another thing that I think makes sense. I saw some people talking about term limits for members of Congress. That's probably a good idea as well. But at least members of Congress have to be elected, right? Every so often. If you're on the Supreme Court, you're there for life. So how do you get onto the Supreme Court? Well, you have to be basically nominated by the president and then confirmed by the Senate, not the entire Congress either, but just by the Senate. And again, and this is again, in theory, supposed to provide a kind of check and balance over the Supreme Court, which, as I've already said, has been given a tremendous amount of power. That being said, people who end up on the Supreme Court, have to go through the other branches of government, before they can get there. And the power. I kind of glossed over the power of presidential appointments, but of course that is an important power given to the president, not just for the Supreme Court, but for lower courts as well, lower federal courts, for the various cabinet offices, the sort of government bureaucracy which surrounds the president, as well as various other federal offices, are appointed by the president, but in all cases, not in all cases, but in most cases, particularly the higher level offices, are approved by the Senate as well. So again, another issue of check and balances. In this case, the Senate has a kind of check and balance over the executive branch, over the people that the president appoints to various high level, at least, executive offices Although there are some officials that the president can basically choose at his or her will, including like the chief of staff, for example, which is a very, powerful position within the government. Although one that did not exist early on either, but kind of came about later. But again, as far as the judicial branch goes, the executive nominates and the Senate confirms. But again, once you're there for life. You can be impeached. There have been a few instances of that. The power of impeachment basically given to the Congress, very similar to how it plays out with the presidency. But again, like the presidency, it's fairly rare. For the most part, again, if you make it up to the Supreme Court, you're basically there for life. And of course, as we've seen, many Supreme Court judges have actually died while in office, or if not, they retire, when they're much older. So Greene's idea, which again I think makes a lot of sense, is to have term limits for federal judges. Now he proposes something I think like 20 years or thereabouts, or is it 18 years or something like that? About 20 years. Seems to make sense. I mean, that's a certainly a long tenure of office to be there for 20 years. Greene makes the point, and again, I think this is fairly obvious that when the Constitution was first ratified, people's life expectancy was much shorter than it is now. Although U.S. life expectancy in the U.S. as I point out has been trending downwards over the last several years, but still higher than what it was in the late 18th century. People weren't expected to live that long. And now also you can certainly see this strategy being employed to get the youngest possible judges on there as you can. People like Brett Kavanaugh and Amy Coney Barrett, for example, are fairly young, relative to the office. So their intention is to have these people serve 30, 40 years possibly on the Supreme Court. That's a very long period of time. So, Greene's idea would more or less cut that down by, half or so. Again, not much to argue about that. I think it's fairly obvious. But again, almost all these issues here deal with the fact that, to get anything done, you basically have to change the Constitution. So one piece I did forget from the New York Times article is that Akhil Reed Amar proposes to get rid of the idea of birthright citizenship, or I'm sorry, not birthright citizenship, but that only a person born within the United States can serve as president of the United States. Maybe part of the reason why I forgot about it for a second is that, again, I would say that's probably not one of the more important ideas. Certainly, yes, it is an antiquated notion. It doesn't make sense that we would have that qualification that only a person born in the United States can serve as president of the United States. It is pretty much a limitation only on the office of president itself. In other words, if you're not born within the United States, you can still serve almost every other office: Supreme Court judge, in Congress, almost any other office that you can imagine. The only limitation, and again, it does stand out for that reason, is that if you were not born within the United States, you cannot become president of the United States. And that's, obviously even taking into consideration that a person becomes a naturalized citizen of the United States. Even if you are an American citizen and you've gone through the naturalization process, if you were not born in the United States, you cannot serve as president. Again, clearly a stupid idea, clearly a backwards notion, but given that it is so incredibly difficult to change the Constitution, and say you actually had a limited window of opportunity for doing so, and let's say one chance at it, basically. I mean, is that what you would almost like a wish from like a genie or something like that? Except instead of 3, you only have 1, or even if you did have 3, is that it? Would that be what you would spend your wish on, basically, to change the Constitution so that people not born in the United States can become president? Again, there's no argument with it other than the fact that I just don't think it's probably the most important thing. I think there's certainly more important things that should be changed about the Constitution, rather than that. But again, yes, as far as the idea itself, there's no argument there that it's obviously not a great idea. So, and I do have a separate PowerPoint for the another stab at the Constitution. I probably won't, since I know the articles pretty well, I probably won't refer to it very much, at least, if at all. I will post it though along with this PowerPoint for this class. So and there are other things about it, the other articles of the Constitution. Let me switch over quickly, because I do have that window open. And I'll switch back to this. So here you have it here. Again, Article 1 being the longest, Article 2 and 3, which we've already covered. Article 4 basically, specifies, I think, relations between the the states and the federal government. As it says here, the citizens of each state shall be entitled to all privileges and immunities of citizens in these several states. Where it's highly, one good thing about where it's highlighted here is that it kind of shows you parts where the Constitution has been changed. This, unfortunately, some of the aspects are, things that originally protected slavery, which we see here. The infamous three-fifths compromise is in Article 1. But things like that. But not too much. Article 5 deals with how the amendments process works, which again, as you can see, is very short. So again, Michael Rappaport, not the actor, talks about the amendment process and how that works. And what he points out is that basically there's sort of a little known second means by which the Constitution can be amended. So as it says here, I'll just read it out real quick since it's so short. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes, blah, blah, blah. Basically, so what Rappaport is saying is that there is a second way of changing the Constitution, which is that rather than going through Congress, what the states can do is basically call forth a constitutional convention, just like the convention which was convened to draft the Constitution in the first place, which incidentally was originally intended to be sort of a reform of the Articles of Confederation. They originally did not intend, or at least did not publicly state, that they intended to essentially do away with the entire original Articles of Confederation. But that's, of course, what eventually happened. So the states have the right to basically call forth a constitutional convention, which would require 2/3 of the states rather than 3/4. Now the problem so Rappaport, of course, is believes that should be changed a little bit, which ironically enough would, I guess, require changing the Constitution to create this change. So there's a little bit of a problem with this argument, but he proposes to essentially, do away with the convention, simply allow, 2/3 of the states to propose constitutional amendments. And then if the states approve of it, then they would become law. The problem with that, though, again, of course, is that, you still have to deal with the fact that you have all this gridlock within government. So even getting 2/3 of the states to approve of anything would be incredibly difficult. I mean, it'd be hard to imagine getting even half the states in the country to approve of something. To get 2/3 would be, God, my math is not great, but I'm guessing somewhere around like 30 states or so, 33 states, something like that. Yeah, I mean that would make sense. Obviously, half of 100, or 2/3 of 50 rather than 100 would be basically like 33 states. You would have to get to sign on to something. That's good. thinking on the fly right there. But yeah, I mean, even getting that amount of states to ratify something would be very difficult. So again, yeah, great idea. And as far as the amendments go, yeah, I mean, again, going back to the fact that many people seem to, focus in on that. Yeah, it's nice that in theory the Constitution is a living document, as a lot of people call it. Of course, that by the way, that notion that it's a living document kind of goes against the conservative interpretation, which tends to stress a very kind of fundamentalist, almost literal interpretation of the Constitution. But our political institution seems so petrified at this point, so rigid, so inflexible. Is it inflexible or unflexible? It's inflexible. Seems so resistant to any kind of change that it's almost unimaginable to think of any of these changes taking place. And there is something to be said about that. I mean, we sort of pride ourselves on the fact that we seem to be, this advanced country and advanced society. I'm talking about even in the present day compared to the past. We often, take it for granted that we're much more, open-minded and, whatever than people were in the past. Yet our way of life seems so hardened. And so, people seem so set in their ways that even making minor changes seems almost impossible. Now, I'm not even talking about just at the level of the Constitution. I'm talking about like almost any aspect of life, even changing, school curricula or something like that to deal with, the COVID pandemic and things like that, and changing work relations and things like that. People seem so resistant to making any kind of change. That it is, it's tough to deal with a society like that, where you're just not able to adapt to things. It doesn't speak well, in other words, to the society that we live in now. That we seem so set in we seem so set in our ways that we can't change anything. Whereas people in the past, with all their limitations, whatever they may be, at least seem to have somewhat of an open mind, at least about changing things, sometimes in often radical ways. I mean, I won't cover all the amendments to the Constitution, but most of them are fairly significant changes. There are a couple that aren't that important, maybe like changing the inauguration date from March to January and things like that, and maybe a few others like that. But most of them are pretty important. And the fact that people, again, given whatever limitations they may have had back then, still at least thought it was possible to make very, what would have been considered at the time radical changes, I think says a lot. And our inability to do so today, I think, says a lot as well. So Article 6, rarely ever talked about. All debts, again, entered into before the adoption of the Constitution will be valid against the current United States government. Hamilton's buddies on Wall Street were very happy to hear about this, because that means that all the war bonds that they bought up very cheaply, they would get paid the full, the full value of, even though they basically bought them for pennies on the dollar. Here's another one of the more sort of obscure contributions. Jenny Martinez talks about this idea that we should pay more attention to the fact that, as it says here, treaties made by the United States have the sort of the force of law, or the same kind of legal status as any law made by the United States, which again is an important thing. Yes, the U.S. has a very bad track record actually when it comes to abiding by international law, even though we point out other countries when they don't do so. The United States, frequently ignores or refuses to sign on to treaties. Does not accept the authority of the International Criminal Court, for example, and things like that. And basically, what she's arguing is that yes, the U.S. should pay more heed to the concept of international law. Again, probably not one of the most important aspects, but one which I agree with. I mean, it's very hard to find any area for disagreement. It's just that I would say, you know, if I'm critical of any of these ideas, I think that maybe some of them are not as significant as others. And that would be one. And again, this is also, you know, where Marshall would interpret the Constitution to give the Supreme Court the power to use judicial review. As it says, the Constitution, skipping over the rest of it, shall be the supreme law of the land, which means, again, anything that's passed that contradicts the Constitution would be then invalid. Now, you're still giving the judges the power to decide when something conflicts with or contradicts the Constitution. You know, you can't assume that those are necessarily clear cut and obvious. I mean, how you come up with those interpretations, of course, is obviously very much a debatable subject. And then ratification of the Constitution basically states that only 9 states needed to ratify it for it to become force of law. So you did not need all 13 of the original states. Of course, all 13 did eventually. Delaware famously being the first state to ratify the Constitution. That's, you know, the Delaware's big claim to fame, I guess. And that pretty much covers, you know, the Constitution itself. We still have to talk about the Bill of Rights, but it is a fairly short document. Not much to it. Now, as far as the question to how democratic the Constitution is, I think it's pretty clear though that the Constitution is not a particularly democratic Constitution. And again, I say that because I see people making the opposite claim in a lot of your writings. I don't think that's a controversial argument. Even fairly mainstream, you know, political scientists like Robert Dahl, for example, who is for a period of time probably the most well-known American political science scholar, would all basically pretty much say, yeah, the Constitution is not a particularly democratic document. I mean, partially that is, you know, relative to other countries' constitutions, which have gone even further in you know, promoting a democratic form of government. But the Constitution is not. I mean, you were in the original form of the Constitution. Not only did the citizens of the country not even have the right to vote for president, you didn't have the right to vote for the Senate. I've already gone over that, you know, large groups of people within the United States were excluded. Women, who basically make up half the population, so you're already basically excluding, you know, 50% of the population from voting. African Americans, whether slaves or freedmen, as they were called, did not have the right to vote. Native Americans did not have the right to vote. And besides that, you had, as I've said, not often talked about, so that's why I'm emphasizing a little bit more, but property rights or property restrictions on the right to vote. You had to own a certain amount of property to be able to vote. Now, some states had already done away with that. Most states would basically do away with it within the next, you know, 30, 40 years, not a insignificant amount of time either. But you did have that in the sort of original formulation of it. And besides that, you know, besides the fact, like I said, that even to this day, technically Americans do not have a constitutionally protected right to vote. It's quite clear if you read the personal correspondence as well as other writings by the founders, they did not have any strong commitment to democracy at all. James Madison, who's supposed to be one of the more liberal members of the founders, believed that only the wealthy people should vote. Again, the wealthy property owners should be the only one allowed to vote. Commoners, people that don't own land and things like that, other people as well, as Madison did, should not be allowed to vote. So I don't know how you can reconcile that with a democratic view of government. I mean, even in the most sort of, like, again, straightforward textbook definition of democracy basically means that everyone has the right to vote for the government, that we have the right to choose who our leaders are, which you did not have in the original Constitution. And it would take literally, you know, like, you know, over 100 years to make that a reality. I mean, even by the standard textbook definition of democracy, I mean, the United States could not really be considered a democracy basically until 1965. That's basically how recent democracy is here in this country. And yes, for people that want to argue the living document thing, yes, that is true, but that even that seems, you know, increasingly, a farther, removed idea from the reality that we have to deal with now. So let me move on to the Bill of Rights. So many of the, contributors to the Times article weigh in on the Bill of Rights, parts of the Bill of Rights, for example. And, I mean, they don't really follow the order here, so I have to kind of jump around a bit. But for example, Rachel Barco talks about, clarifying what it means, to prohibit cruel and unusual punishment. So that is the Eighth Amendment. As it says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, as she states, well, what does that mean? I mean, part of the, and I'll go back. I'll go through the amendments in order, but that one just jumps out to me because, yeah, she's right. I mean, what does that mean? What is cruel and unusual punishment? Is it torture? Well, the problem with that is that even that's a lot. The United States does torture people to get information out of it. Some people would say that, putting a prisoner in solitary confinement is cruel and unusual punishment. Some people will say that imprisoning people at all is cruel and unusual punishment. So how do you define what that is? Same with the first part of the statement. What constitutes excessive bail? How do you define something like that? So there's a lot of ambiguity there, obviously, and that is probably to some extent intentional. It doesn't go well with a sort of conservative, what I often call, the fundamentalist reading of the Constitution. Because I mean, that is essentially what they are doing. They're taking a fundamentalist sort of like, literal approach, just like a fundamentalist, religious adherent takes a what they consider to be a literal approach to their sacred scripture. It's so vaguely worded that how can you take any sort of literal interpretation out of things like that? So that certainly speaks to that. Now, so Barco is very much involved in the idea of criminal justice reform. So that's why, of course, why she focuses on that. Of course, as I've already highlighted already in previous classes, the United States has one of the worst, or I should say, has the highest, prison incarceration statistics of basically any other, country in the world. We imprison more people, at least as a percentage of our population, than pretty much any other country, and in most countries, in terms of real numbers as well. Often, the case for non-violent crime, and there's a clear racial disparity to that. I provided some links in one of the previous classes, so you can go through and look through that more. But one which stands out to me, at least, is that African Americans within the United States only make up about 13% of the population, but 40% of the prison population, and that's the what people call the disproportionality of the how things disproportionately fall negatively on Black and other minority groups within the United States. Now, the thing about the disproportionality thing is that it's a little more complicated than people might first think. I mean, a lot of people would probably think, oh, the majority of people in prison are Black. Well, that's actually not true. 40% is not the majority, but it is disproportional. In other words, not in proportion to the number of Black people that are within the United States. Proportional would be, if they're 13% of the population, they should be about 13% of the prison population, or at least close to that. But 13% to 40% is not even close. I mean, it's more than double, in fact. So that's what people mean by disproportionality. It's important thing to keep in mind, because again, I think people hear that term a lot, but I don't think they always know what it means. And it doesn't necessarily mean that you're the majority. Now, maybe if you add up, say, like Black and Latino people, maybe you do then get to a majority. I'm not even sure, although I'm sure some of those websites probably have the statistics on that. But in any case, it's not as if there's not a significant amount of white people in prison as well. And as far as the racial disparities goes, yeah, those are obviously important. But the class, disparity there is even more prevalent, right? I mean, and I think it's fairly obvious, but I mean, most people in prison, of course, are poor. There's not many, wealthy people locked up in prison at all. It's not because wealthy people don't commit crimes. They may not commit the same kind of crimes, but I mean, they do commit crimes. But the sort of class basis of incarceration is even more, sort of flagrant than that. Anyway, so let's just go through them real quick. Again, fairly short. So you have Amendment 1, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So Pauline Maier, again, one of the contributors to the Times article, does not like the wording of this. She thinks, she refers to it as stingy, I think she says. That it should have more sort of inclusive language. Okay, I mean, again, that's another one that's like, all right, yeah, sure. I guess we could rewrite the First Amendment. I think her point is that, which is a very good point, is that the First Amendment right is applied to corporations, right? That we equate money with freedom of speech. Well, is that really speech? Spending money on an election? Can't you make the argument that wealthy people can use their money to essentially push other people out of the election process, to essentially monopolize, as it were, political communication within the country? You certainly could make that argument. That is not the opinion of the Supreme Court, unfortunately. And the idea that corporations are people and are entitled to First Amendment rights, another very dubious interpretation of the Supreme Court. She's absolutely right that interpretation of the First Amendment is not a good interpretation. I don't see how necessarily rewriting it would necessarily deal with that, though. I mean, it would still basically free judges to make what any kind of dubious interpretation that they want to make. Basically, I understand that the language somewhat constrains what you can do, but I mean, if there's anything that we've seen from how the law is interpreted in the country, is that it's very easy to make very questionable interpretations of things. So I don't necessarily know how rewriting the First Amendment would necessarily prevent the things that she's talking about, unless you make it so abundantly clear that corporations are not people and money is not a form of speech. But she doesn't, as far as I can recall, actually say that. She just proposes a slightly reworded, First Amendment, more or less, preserving the original language. Anyway. So there you go. So Melinda Price points out the Second Amendment. Except I'm not exactly sure what her argument is, other than we should get rid of it, I guess, which is what a lot of people say. Again, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, of course, people only just focus on that one part where it says the right of the people to keep and bear arms shall not be infringed, and tend to ignore the first part of it. Which kind of dates this amendment, right? The idea of a militia, these kinds of volunteer military units, which played a great role, of course, in the American Revolution, were important back then. But this idea that people are going to, I mean, what are people going to do? They're going to take up arms against the government, or they're going to take up arms against the foreign invader. The United States doesn't face any foreign invasion threats, although that may not always be clear, or if you listen to the media too much in the country, they may not have you think that. But now things like nuclear war, I definitely think is something that we have to worry about. But having the right to bear arms isn't going to do anything about that. So yeah, I mean, this would be another thing. Yes, I mean, I think it's a little outdated. Should people have the right to own firearms? I mean, that is a good question. I think people probably should. I think there should be, limitations on it. I don't think necessarily people should have, assault rifles and things like that. And of course, you can't talk about this issue without pointing out the, tremendous gun violence that occurs within the United States. Again, something else that stands out in this country. I mean, the number of handgun deaths and firearm deaths in this country significantly higher than what you see in most other countries. And most other countries do have much more restrictive laws about owning firearms. And it's hard not to say that there's a connection between those things. That if you had more restrictions on the ownership of firearms, that you would probably see a dramatic decrease in the amount of deaths. So let's see. I think I've probably covered pretty much all of them, all the contributors to the New York Times article. I know Elizabeth Foley talks about federalism. We'll talk about that more next class. Amendment 3 is very weird. No soldier should be quartered without the consent of the owner. Again, another very, very dated reference. The other amendments, though, of course, are very important. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. So the idea of the protection against unreasonable searches and seizures, and that the government needs warrants, again, very important restrictions on the power of the government. Fortunately, they don't really mean anything anymore. In our post 9/11, post Patriot Act world, and things were already heading that way before then, the government's ability to search and surveil people, as well as, seizing people, is almost unquestioned. I mean, and certainly with very little limitations upon it. So, we'll talk about more about the different sort of kinds of rights later on in the class. But even the notion of civil rights are very much insecurely held, and I don't see, how people can ignore that. Clearly, the government has significant power in that regard, in ways which probably even unimaginable to the people back then. The idea that you would have surveillance cameras everywhere, that you would be tracking people's emails and following what they're doing on the internet and things like that, obviously goes well beyond what they probably could have imagined. But again, the government has very little restrictions against those things. So the idea that our civil rights are basically being eaten away at or eroded, I think is very important to keep in mind. And maybe that's an important reason why we should go over these things, to realize, what it does say in the Constitution. So the Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentiment or indictment of a grand jury. Nor shall any person be subject to the same for the same offense to be twice put in jeopardy of life or limb. You can't be charged for the same crime twice. I have a right to a grand jury, which is not always true anymore. But the grand jury system as sort of, again, another limitation on the power of the government. A grand jury sort of precedes, a trial by jury, basically, where a grand jury basically has to decide if there's a good reason to indict a person, to basically charge a person with a crime. That is mostly true at, the state court levels. Federal courts have actually sort of, kind of gotten around that a little bit. But the most important part of the Fifth Amendment is that it says a person shall not be deprived of life, liberty, or property without due process of law. This has become known as the Due Process Clause. And you'll see another version of this in the 14th Amendment. Again, very important thing. What it basically says is that the government has to follow rules, basically. The government can't just do whatever it wants. It can't just, drag you off the street, although, again, sometimes it does do that. And, throw you in prison or penalize you in some way without some kind of legal process, guiding what they're able to do. Now, that is what is often referred to as procedural due process. But there's also the idea of what they call sometimes substantive due process as well, which basically states that even if all the legal protocols are being followed, there's still the question of whether or not the government has a good reason to deprive someone of life, liberty, or property. And if the courts find that the government does not have a good reason to do so, then again, those actions by the government can be basically ruled to be illegal and unconstitutional. And in that case, and we'll talk about this more when we talk about the Supreme Court. But what that says, what that idea implies, again, is that even if all the proper legal procedures, like I just said, are being followed, it can still be found that the government has acted in an illegal way if they're sort of exceeding their authority. But again, these are all great ideas, but the problem is that as things seem to be heading in this country is that the government is progressively sort of weakening these restraints and taking more and more power upon itself and undermining these things. The Sixth Amendment says everyone has a right to a speedy and public trial. Again, the idea of a speedy trial. Look at some of the people backed up in the New York criminal justice system. Granted, this is the Constitution, but this idea has gradually been extended that of course all people should have a right to trial. Trials are not particularly speedy. I think like something like 80% of people do not ever who are charged with a crime do not ever even have a trial. There's so much pressure upon people to accept a plea bargain, which is where you basically plead guilty to a lesser crime. That is true. The vast majority of people never actually get a trial, even though the Constitution says that they have a right to a trial. And even when they plead guilty to a lesser crime, still often, obviously have to, do jail time in many cases. The Eighth Amendment, again, another sort of, dated antiquity, has been, superseded. So we don't need to deal with that. But, basically, it's saying if you're in a lawsuit where the controversy charges you $20, you have a right to trial. If it's less than $20, then maybe the judge will just rule upon that. Again, like I said, very dated idea. Eighth Amendment we already went over. The Ninth Amendment, very important amendment, kind of understated in its importance. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Meaning what it's basically saying is that, yeah, there are possibly other rights here which are not specifically spelled out, which does not mean that the people do not have those rights. So again, I would say that very much sort of, contradicts a fundamentalist interpretation of the Constitution, where people, for example, in the recent case on abortion, which we will cover later on in the class, the conservative majority on the court said, well, basically because, it doesn't actually specifically say the word abortion in the Constitution, it does not mean that a woman has a right to an abortion. That is contradicted by things like the Ninth Amendment, which is saying that, look, there are rights which people have which are not specifically spelled out here. And then the 10th Amendment says power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. So there you have pretty much the first 10 amendments. Now, I'm not going to go through all of them, but let me go through some of the more important subsequent amendments, which of course are all part of the Constitution now. Amendment 12, I said, sort of clarified, the candidates will, for this point, run on a single ticket. The original system was that whoever got the first and second highest number of electoral votes would become president and vice president. This quickly led to a constitutional crisis in the election of Thomas Jefferson and Aaron Burr. Aaron Burr, they tied basically. Aaron Burr did not want to step down, and so they, as you can see, this was the election of 1800. Just a few years afterwards, they passed this amendment. Again, not the most important thing in the world, but it did lead to an early constitutional crisis. But I want to get to the really, outside of the Bill of Rights, probably the most important amendments are the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, especially the 14th Amendment. You can make a very good argument that the 14th Amendment is probably the most important amendment, in fact, within the Constitution. So the 13th Amendment, which was famously, sort of portrayed in the movie Lincoln, the passage, of the 13th Amendment. Neither slavery nor involuntary. Oh, and it even tells you, how this amendment basically changes previous parts of the Constitution. So it invalidates, Article 4, Section 2. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Now, people's off, of course, this is the amendment that bans slavery within the United States. Now, many people would argue that the idea, except as punishment for crime, is kind of like a loophole that essentially preserves slavery. Just that now you have to be basically convicted for a crime before you become a slave. Now, a lot of people have written about this and talked about this already. There was the documentary 13th, which kind of goes into this issue, which kind of makes the argument that after slavery ended and then after Jim Crow ended, which of course lasted for another 100 years of segregation after this, that you quickly see the development of the mass incarceration state within the United States, particularly, targeting African Americans. And the numbers, the historical timeline certainly makes sense as far as, you see a massive increase in the prison population, basically, from the 1970s onward. Segregation basically ends, Jim Crow basically ends the late 1960s. So that makes sense. Again, I think defining everything in terms of, racial disparities and things like that has its limitations, though. And not to say that it's not true, but I think there are other things that have to be looked at as well, like class and things like that. Again, the class connection between incarceration is much higher. Almost everyone, like I've already said, in prison basically would be considered poor or lower income. But anyway, so some people interpret this amendment in light of the sort of explosion of incarceration within this country, and I'm not inclined to disagree with that either. I think that there is probably some truth to that. That being said, people often point to the prevalence of private prison industries within the United States. Those are certainly, it's certainly an odd thing that you had people that would run a for-profit prison, but that's capitalism. However, private prisons only make up, I think, about 10%. I mean, again, go back to those articles, like the prison policy initiative that I provided a link for in one of the PowerPoints. But they make that claim that private prisons, I think, make up no more than 10% of carceral institutions within the United States. So a fairly small amount. Not to say that is not still significant in its own right. And again, it is sort of an odd thing that people would seek this out as a way to make a living. But again, going back to what Mark said about the commodity, that's what essentially now what we're talking about is the commodification, not just of physically produced goods, but the commodification of services. In this case, the service of maintaining a carceral institution. And that is essentially, what happens when you commodify everything. Is that the profitability of things, or what Marx would call the exchange value of things, is really all that really matters. Doesn't matter what you're actually doing, right? That's sort of incidental and secondary. All that matters is that, can you find some way to make a profit doing something? And, if you can make a profit running a prison, then you're going to find people that can do things like that. Anyway, so now going on to the 14th Amendment, which you can see is significantly longer, although really only Section 1 is the most important part. So as it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, this is arguably possibly only second to the First Amendment, but I think you can even make a good argument this is more important. The most important amendment within the Constitution. Why? Because what it basically states is that, well, it's certainly been cited by the Supreme Court more than any other amendment. But what it says is that, first of all, that anyone born within the United States is now a citizen of the United States. And of course, given the timeline of it, was intended obviously to give citizenship to the freed slaves. This is obviously happening after the Civil War. Also, I should say, in response to Andrew Johnson, vetoing several attempts to pass legislation like this. In many ways, the Congress was essentially forced, had their hand forced by Johnson to pass these amendments, at least the 14th Amendment, because of the sort of stubborn intransigence of the current president of the United States, which of course would culminate in his own impeachment, which he just narrowly avoided. But that's certainly one aspect of it. Now that extends to this very day, and of course, and anyone who's born within the United States, whether your parents are citizens or not, if you're born within the United States, you become a citizen of the United States. The privileges and or immunities clause, as it's known, is somewhat vague. That does reference the language that's used in Article 4 of the Constitution, but particularly the last two clauses, the due process clause, which again you already find in the Fifth Amendment, but notice how it's rewritten here. Nor shall any state deprive any person of life, liberty, or property without due process. So now it's specifically applied to the states as well, not just to the federal government. And also, by the way, I should also point out that it doesn't specify anywhere, except for the privileges or immunity clause, but it states that persons, right? It doesn't even specifically say that a citizen of the United States is entitled to due process of law, but anyone, basically, citizen or not, is entitled to due process, nor deny to any person within its jurisdiction the equal protection of law. So as it says, nor shall any state deprive any person, not just citizens, but any person, period, or nor deny to any person within its jurisdiction the equal protection of laws. So this idea also, the idea that you cannot have a discriminatory standard of law against one person or another. And that has been construed in many ways as well, some of which we'll talk about again later on. Now, again, we know just because this is put in the Constitution doesn't necessarily mean that it became a reality. And of course, as we know, that segregation would continue for a long period of time after this. Although it wasn't until really the Reconstruction period ended, which is about 10 years or so after this, as you can see, passed by Congress 1866, ratified 1868. Reconstruction is generally considered to have ended around 1877 or so. And that's it. I won't read out all of this stuff, but and then of course the 15th Amendment, right of citizens to the United States to vote shall not be denied on account of race, color, or previous condition of servitude. So again, it doesn't necessarily say that all citizens have the right to vote. It uses negative language rather than positive language. It's saying you can't take away their right to vote based on a person's race or color. And something else which we know that even though it was passed, did not become the reality. Although for a period of time, again, during Reconstruction, Black people in the United States were able to vote and then had that right basically taken away from them. Largely with the sort of terrorist activities of the Ku Klux Klan. But another important part about this is that it does not specify gender, even though the women's rights movement, the suffragette movement, was already well underway at this point. And in fact, prior to this, the women's rights movement, as it's sometimes known as, and the abolition movement prior to the Civil War, were very much on the same page. We're very much aligned with each other. Elizabeth Cady Stanton, Susan B. Anthony, who we'll talk about again in a future class, were very much, and people like Frederick Douglass and Henry David Thoreau and William Lloyd Garrison were pretty much, sort of a united movement at this point. And there are people that suggest that perhaps the 15th Amendment was a way of sort of divide and conquer. We're going to split these people up. So we're not going to specify gender. So we're going to essentially turn these movements against each other, which did happen. Women's rights activists protested the 15th Amendment, did not support the 15th Amendment because it did not give the right to vote to women. Whereas, again, the abolition movement, who later, morphed into the, I guess, early civil rights movement, of course, did support the 15th Amendment, Frederick Douglass and people like that. So interesting how that kind of played out as well. Then it's, a long time basically until you have any other amendments. It's not really until the Progressive era, the time, shortly before World War I, which we spent a little bit of time talking about in class. One of which is to create the 16th Amendment, which gives the Congress power to lay and collect taxes on incomes. Which again is a progressive tax, meaning that the higher your income, the more you get taxed. And it's quite clear. Let me switch back over to the PowerPoint. That the intent of this is not just as a means of raising revenue, but it is basically a tool to prevent inequality from becoming too severe within the country. Excuse me. So the first income tax was actually during the Civil War. That was a sort of temporary wartime measure. In 1894, Democrats attempted to pass, did in fact pass the first income tax, but it was later ruled unconstitutional by the Supreme Court. Now, opponents of the tax, and I think this says a lot about the politics around it, denounced it as being a socialist thing. Opponents called it socialism, communism, devilism. It's literally satanic, according to Senator John Sherman. A communist march on private property, according to Joseph H. Choate, Dean of the New York Bar. An assault upon capital and a war of the poor against the rich, Justice Stephen J. Field, who later
took part in the decision to invalidate the income tax. Field also took part in the 1886 decision to rewrite the 14th Amendment, or I should really say reinterpret the 14th Amendment to mean that corporations were people and entitled to immunities and privileges. So great guy there, obviously. Let's take an amendment meant to protect former slaves and use it to protect corporations instead. But the notion of an income tax, again, was clearly a means of sort of, preventing the level of inequality in the country from, sort of escalating to uncontrollable means. It's not just a tool of raising revenue to pay for government programs and things like that, but it's basically meant to keep, the country within a certain level of equality. And that's an important thing because, as we've talked about, and in spite of the income tax, we've seen that the concentration of wealth and the explosion of inequality in this country has transpired anyway, mainly through finding loopholes to in many cases avoid paying the income tax, as we know with Donald Trump, for example, and people like that. Now, do I talk about so here you see the sort of differing levels of the income tax. Now, it is a progressive tax, meaning people at different income levels pay at a different tax rate. So here you see the highest income rate and the lowest income rate. The highest, which obviously is more important here, has sort of changed from period of time, getting quite high to getting quite low to getting high again during the middle of the 20th century to basically since about 1980, Ronald Reagan has dropped to historically low. Now, Reagan himself famously had to raise taxes because he did cut them so low. They wouldn't be able to pay for their Cold War arms buildup against the Soviet Union. George Bush, successor to Ronald Reagan, famously quipped, he was not going to raise taxes anymore. Of course, was also forced to reverse himself on that. But basically, the sort of dance that you've seen since then is sort of this, whereas, a Democratic president will try to raise taxes a little bit, a Republican will come in, cut taxes a little bit more, Democrat will come in and raise them up a little bit, but not as high as they were prior to this. And of course, the net effect is that you have a very low income tax rate on the highest earners. Now, this is in spite of the fact that, again, there are all sorts of loopholes and there are all sorts of ways for people to avoid paying the tax. If you go to the middle of the 20th century when the income tax rate was quite high, It's commonly known that most people did not actually pay that amount. You know, there are all sorts of ways for them to deduct things based on their business expenses and things like that. So very few people pay, you know, at its peak level, a 90% income tax rate. Very little, if anyone, ever actually paid that. So keep that in mind. Now, did I talk about the 17th Amendment? Okay, so then after this, I go into the Federalist Papers, but let me switch back over again to this. So, yeah, so the 17th Amendment basically allows for the direct election of senators. Again, not until 1913 could you even vote for your senators. The 18th Amendment, the Prohibition Amendment, Al Capone's favorite amendment to the Constitution. Not a good one there. I think everyone knows the story of that. And then the 19th Amendment, which did finally give women the right to vote, which did not take effect until 1920. It was not until 1920 the women actually had the right to vote in this country. So those are the progressive amendments. Not as probably well known as the Reconstruction Amendments, the 16th, 17th, 18th, and 19th Amendment. But we can say very important, and at least three out of the four are good amendments. Not the 18th Amendment, obviously, but the rest of them are important. And then from here, I'm not going to go through all the amendments, but this is the one which changes on Inauguration Day. I mean, it probably does speak to this. Is in the 1930s when FDR was president, or just had become president. It probably does speak to the growing importance of the office of the presidency, which many people refer to FDR as the first modern president, things like that. They got rid of the 18th Amendment with the 21st Amendment. This is the one, also in response to FDR, which limits presidential terms to 2 terms in office. All right, and so on and so forth. So let me turn over now to the Federalist Papers, if I can get back there. So the Federalist Papers were, excuse me, basically essays written in newspapers in support of ratifying the Constitution. John Jay contributed a little bit, but mostly, they were done by Madison and Hamilton. And Hamilton, in fact, wrote most of them. Anyway, I'm not going to go over all of them. You do have access to all of them from website link. But Federalist 10 particularly stands out to me as one of the most important amendments because what it says basically is that it kind of gives you the most sort of general argument for why you have the Constitution, which is to prevent what Madison calls, believed to have been written by Madison, factions. And he sort of lays out the argument here in this very famous passage where he says, so after first introducing the idea of factions and the problem of factions, he says there are 2 methods of curing the mischiefs of faction. The one by removing its causes, the other by controlling its effects. Interesting. So he says there are again 2 methods of removing the causes of faction. The one by destroying the liberty which is essential to its existence. The other by giving to every citizen the same opinions, passions, and interests. It could never be more truly said than of the first remedy that it was worse than the disease. Liberty is to faction what air is to fire, an ailment without which it instantly expires. But it could not be less folly to abolish liberty, which is essential to political life because it nourishes faction, than it would be to wish the annihilation of air, which is essential to animal life because it imparts to fire its destructive agency. Essentially what he's saying is that you can only basically deal with the effects of faction, right? You can't deal with the causes because the causes are sort of ground in liberty itself, he says. And so essentially what the Constitution is meant to do is to control the effects of faction. But where do these factions come from and what are these factions about? Well, interestingly enough, he locates the biggest source of factions in conflicts over property, which is essentially he's making a kind of class-based argument. So he says the latent causes of faction are thus sown in the nature of man, and we see them everywhere, brought into different degrees of activity according to the different circumstances of civil society. So strong is this propensity of mankind to fall into mutual animosities that where no substantial occasion presents itself, the most frivolous and fanciful distinctions have been sufficient to kindle their unfriendly passions and excite their most violent conflicts. But the most common and durable source of factions has been the various and unequal distribution of property. Those who hold and those who are without property have ever formed distinct interests in society. Those who are creditors and those who are debtors. In other words, the conflict over Shays' rebellion, for example. The debtors, mad that they owe money to these other people, fall under a like discrimination. A landed interest, a manufacturing interest, excuse me, a manufacturing interest, a mercantile interest, a moneyed interest with many lesser interests grow up of necessity in civilized nations and divide them into different classes. He even uses the term class, actuated by different sentiments and views. The regulations of these various and interfering interests form the principal task of modern legislation and involves the spirit of party and faction in the necessary and ordinary operations of the government. So interesting that he would point that out. And again, basically say that, class conflict, or sort of regulating class conflict, essentially, is the most important part of government. And you find this, throughout history. I mean, again, Plato and Aristotle held to very similar views. Marx, in his own way, held to that view as well, though much more, radical version of stuff. In fact, I have a quote from Marx here, again, from another letter he wrote to Joseph Weydemeyer, who was actually an American socialist. And he says, now as to myself, no credit is due to me for discovering the existence of classes in modern society or the struggle between them. So he's saying, look, I didn't invent this idea. Of course, Marx is identified with this idea, but he did not, come up with it himself. Long before me, bourgeois historians had described the historical development of this class struggle, and bourgeois economists, the economic economy of the classes. What I did that was new was to prove, one, that the existence of classes is only bound up with particular historical phases in the development of production. And two, the class struggle necessarily leads to the dictatorship of the proletariat. And three, that this dictatorship itself only constitutes the transition to the abolition of all classes and to a classless society. And I think that is true, obviously. I mean, quite clearly, people before Marx talked about the importance of class conflict in society. He says that I realize the classes are tied up to the different the different systems of production that exist, whether it's agricultural, industrial, for example. But the other 2 points are interesting as well. What is this term, the dictatorship of the proletariat? Very infamous term, one that sounds a little bit, sinister sounding maybe. But basically what Marx is arguing is that this culmination of this process leads to the working class basically taking power and sort of using the power of the state, so he believes, to appropriate capital and to sort of break down sort of the private ownership of the means of production, to sort of pave the way to a socialist society. Now there's a lot of confusion that stems over this term. Many different theorists have interpreted this in a different way. Does the so-called dictatorship of the proletariat itself constitute socialism? Some would say yes. Some would say this is the first stage of socialism. I think it's quite clear, though, from reading Marx and Engels, though, that they did not actually intend this to be the first part of socialism. That this, in fact, sort of precedes socialism. That before you get to socialism, in other words, you have this kind of, sort of revolutionary overthrow of the bourgeois state and the sort of creation of what he calls the dictatorship of the proletariat. And that what he's saying that itself, as he says, constitutes the transition to the end of a class-based society. Now, those are obviously the differences from what, you know, Madison is saying, for example, but they did at least agree upon the importance of class conflict, as I said. Now, what Madison, of course, would hold on to, and again, Madison is the one that thinks only, you know, by the way, you know, rich people should be allowed to vote. Is that you should try, you know, the best you can do is try to regulate class conflict. You can't eliminate it. Marx would, of course, say that, no, this process will eventually sort of exhaust itself. Now, I'm not going to go into all of that. I would say that the idea of the dictatorship of the proletariat, at least Marx and Engels' idea of it, is not probably as sinister as it probably first appears. And again, as this term was then picked up by later people, like Lenin in the Russian Revolution, who obviously, you know, took this in a much more either literal way or misinterpreted what Marx meant. But their sort of model, Marx and Engels' model for the dictatorship of the proletariat, is actually found in something known as the Paris Commune of the 1870s. I'm not sure if people have ever heard of that before, but basically what it was a brief moment in time where the workers in Paris basically rose up and took control of the city government. Not the entire country, but just took over the municipal government of the city of Paris for about 2 months, I think. And this happened after France lost the war. And I think that obviously played a big role in creating the opportunity for them to do this. But for that brief period of time where they actually held on to power, it was a very sort of, you know, radical experiment in democracy, actually. It was not an actual, you know, authoritarian government. The workers there did elect people to act as their representatives, but they could you know, instantly recall these people through a vote. In other words, the representatives once elected and very, very much different from the kind of communist parties that you saw in Russia and China and so forth, were very much accountable to the people. They did not just become the sort of ruling clique that didn't have any you know, accountability to the people that voted for them. Now, it was put down quite quickly and quite brutally by the French government, and I think, you know, the estimates are that something like, you know, 20,000 of the so-called communards, as they were known, were basically, you know, massacred by the French government. But it did sort of, you know, represent this sort of brief moment of you know, working class power, and it was a democratic, you know, political order. It was not an authoritarian order at all. So that actually probably comes a lot closer. I mean, in fact, you know, they said quite explicitly that was sort of their model of this idea. Now, as you can see, Marx's letters from the 1850s. So it took him a long time before he could find something that sort of, you know, embodied those ideas. But when it finally came in the 1870s, that's pretty much what they meant by it. Obviously, you know, as this idea was picked up, like I said, by later communist movements, it definitely went in a much different way. Now, I'm sure most people would probably think that, you know, the idea that you should contain class conflict probably makes a lot more sense. The question is, can you really do that, though? I mean, if anything, as we're seeing what's going on within the United States now, is that all attempts at sort of, you know, restraining the level, you know, regulating the level of inequality within society and things like that are breaking down, and in fact have already broken down. I mean, you know, it's been a, you know, a 40-year trend basically of greater inequality within this country. It's not just some kind of fluke or anything like that. And as we know, prior to the Great Depression, you saw a massive level of inequality then as well. So, you know, I'm not going to go into that whole issue, but I mean, it is a worthwhile question to take up. I'm not quite sure that you can really regulate class conflict the way in which Madison believed. And again, Madison's idea is basically only let rich people vote, which I think would be a view that most people don't agree with anymore. I want to say something else about that. Well, all right, and so, you know, as far as how democratic the Constitution is, I mean, you could also basically argue that the whole point of the Constitution, in many ways, is to prevent this kind of so-called dictatorship of the proletariat from ever taking place. It's, you know, essentially created to make sure that working class people never actually take power, and will always be sort of, you know, subject to the limitations of the Constitution, which, you know, essentially allow for the, you know, sort of permanent dominance of the wealthy classes within society, which has been a constant fact of American life, basically from its origin to the very end. And so Hamilton talks a little bit about this also. Hamilton was even more, you know, conservative in his view. Again, also sort of, you know, shares in this idea of class conflict too a little bit. He says all communities divide themselves into the few and the many. The first are the rich, and well-born, the other, the masses of the people. The voice of the people has been said to be the voice of God. And however generally this maxim has been quoted and believed, it is not true. In fact, the people are turbulent and changing. They seldom judge or determine right. Give, therefore, to the first class a distinct permanent share in the government. They will check the unsteadiness of the second, and as they cannot receive any advantage by a change, they therefore will ever maintain good government. And again, his idea of good government is, you know, allowing Wall Street speculators to profit off of, you know, the backs of soldiers and farmers and things like that. Can a democratic assembly who annually revolve in the mass of people be supposed steadily to pursue the public good? Nothing but a permanent body can check the imprudence of democracy. It is admitted that you cannot have a good executive upon a democratic plan. Again, very negative towards the idea of democracy. So I think that's pretty much it. Oh, well, there's this. All right. Well, I've covered some of this stuff already, the explosion of debt and things like that. I want to, because I've been talking for a while now, I want to sort of wrap things up a little bit, but I want to go back here. So, first of all, so you might think at this point, well, I sound pretty critical of the Constitution, and I am to some extent. But here's an interesting thing. This is the World Socialist website, pretty well-known socialist website, and their critique of the so-called New York Times' 1619 Project. Now, I'm assuming most people have at least heard of the New York Times' 1619 Project. It's much more critical of the American Revolution and Constitution than anything I've said, where they essentially argued that the revolution was essentially about, you know, enshrining the power of slavery, empowering the slaveocracy at the expense of any kind of democratic ideals. I think as this article, and maybe I'll, you know, provide a link for this if you want to go through this, because it's pretty thorough. They point out, to say the least, a lot of the flaws in the kind of historical research that went into this, as well as, I think probably maybe the most interesting part is provide a series of interviews with historians who were not consulted by the New York Times when they were coming up with this. And it's quite odd because these are, you know, generally considered to be the most influential or most authoritative, let's say, historians when it comes to the Civil War, the American Revolution. The Civil War also, you know, comes in for a lot of criticism by the New York Times. So you have Victoria Bingham, who wrote the book Free State of Jones, which was later adapted into a movie, interesting movie about poor whites and blacks, you know, a true story about poor whites and blacks basically aligning against the slaveocracy there. James McPherson, James Oakes, Gordon Wood, Adolph Reed Jr., who was canceled by the DSA, the Democratic Socialists of America, for being a so-called class reductionist, for basically talking about class too much. Being canceled by a socialist organization for doing something like that is certainly odd. So I would encourage anyone to read things like this. But what stands out here is that, you know, this is a far left Marxist website, and yet they're actually defending the American Revolution against the, you know, sort of affluent liberals that read the New York Times, you know, which would presumably be the audience for something like this. So it is kind of an interesting thing. It is kind of an interesting contrast. I mean, when I say far left, I mean these are basically people who identify themselves with the theories of Leon Trotsky, who was one of the leaders of the Russian Revolution. It was later assassinated, is believed, on Stalin's orders. So it's very, very far left. But yet they actually, I would say, do a better job basically of defending the progressive aspects of the American Revolution than what you would see in the New York Times. So the great irony here is that, you know, the Marxists are actually defending America against the liberals, you know, who, like I said, read the New York Times and stuff. So that's interesting. I'll include that link if anyone wants to look at it. So they do, you know, yes, I mean, unquestionably, well, but for anyone besides, you know, the New York Times readers, the American Revolution was an incredible step forward, and even the Constitution, for all its flaws, was an incredible step forward, as was the Civil War, which I did not really talk about. It doesn't mean that you look through everything through, you know, what's that term, rose-colored glasses or rose-tinted glasses. You can acknowledge the limitations of it, which I think more people should do, probably don't do enough. But you have to, you know, properly situate it in its historical context and realize what a, you know, momentous occasion it was. And I won't go into that too much. I mean, you know, again, if you want to, you know, read some of this stuff, read this introduction, and they pretty much spell all that stuff out and peruse through the various other parts of the website. Now I want to play a short video clip by Franklin Roosevelt, which I think is interesting. So as far as the New York Times goes, another stab at the Constitution, 10 people who have their ideas for how to fix the Constitution, some of them good, some of them not bad, but I don't think as important. Not one of them sought to include things like healthcare, a right to education, a right to housing, or any of those things, which I think does show a certain limitation in their intellectual imagination. Maybe they're just afraid to say these things. Maybe their, you know, jobs essentially, you know, depend on them, you know, sort of towing the line a little bit. But I want to play this short clip from Franklin Roosevelt's was often referred to as a second Bill of Rights, or sometimes referred to as the Economic Bill of Rights. And I think that'll kind of speak to what I'm talking about here.
In our day, certain economic truths have become accepted as self-evident. A second Bill of Rights, under which a new basis of security and prosperity can be established for all, regardless of station or race or creed. Among these are the right to a useful and remunerative job, the right to earn enough to provide adequate food and clothing and recreation, the right of every farmer to raise and sell his products at a return which will give him and his family a decent living, the right of every businessman, large and small, to trade in an atmosphere of freedom from unfair competition and domination by monopolies at home or abroad. Right of every family to a decent home. Right to adequate medical care and the opportunity to achieve and enjoy good health. The right to adequate protection from the economic fears of old age, sickness, accident, and unemployment. The right to a good education. All of these rights for unless there is security here at home, there cannot be lasting peace in the world.
So there you go. And again, I think says a lot about the country now that, you know, 80 years later, not only have none of these rights become constitutional rights, and I think the term a second Bill of Rights quite clearly shows that to be the intention here, but people don't even talk about it anymore. And what, you know, it speaks to a kind of, you know, intellectual regression on the part of people, that they don't even like think to, you know, even ask for these things anymore. An intellectual, at the very least, a kind of, you know, political regression. Something's wrong with our politics, that we, you know, these are now sort of outside the realm a possibility, apparently. And again, if you've heard it once before, you've probably heard it a million times. But at the end of the day, it's still one of the most effective arguments that you can make. Most other countries have these things. Most other countries have, guaranteed health care and things like that, and free college, and all those other things, and much more extensive public housing and things like that, instead of the kind of crappy junky public housing that we have here in this country, to the extent it exists at all. So if I'm somewhat critical of the New York Times article, I'm not talking about the 1619 thing, which I think is kind of a shoddy piece of scholarship, but I'm talking about the knowledge they have at the Constitution piece. I agree. Yeah, let's get rid of the Electoral College and things like that. But the fact that people never even thought to include any of these things. Now, as a sort of complementary to this, here's an even more recent piece from the Washington Post about fix this democracy now. 38 ideas for repairing our badly broken civic life. So they acknowledge that our politics are kind of screwed up. I don't have the time to go through this right now because I see I've been talking for a while. I want to, like I said, wrap things up. But I'll just simply say, I mean, these ideas are completely stupid for the most part. I mean, it is embarrassing, in fact, that something like this was even published. Yes. By the way, yes, the first idea is here: require everyone to vote. Yeah, more people should vote. Forcing people to vote, I don't necessarily know if that is a good thing. But voting, not a lot of people vote in the United States. That also has a very clear class element to it. Poor people don't vote, generally speaking. Most people who vote generally tend to be older people and people who generally have more or higher incomes, as it were. But yeah, more people should vote. I'll say that. But some of these other ones are we should teach Identity 101, go 1 month without social media, befriend a libertarian. If I had more time, I would go through this more and kind of poke fun at these ideas more. I'll include this also as a link because it's almost amusing to read it, but it's embarrassingly bad in how, again, superficial and shallow and limited, again, the intellectual horizons are of people in this country. And again, these are 38 people, 10 from the other articles, so now almost like 50 people now, all of whom are fairly prominent people, all of whom are, I think you could safely say are part of the American elite who write books and articles, or journalists, or people in public life. Many of these things are, basically, essentially, the theses to probably, books that have been written on these topics. And it's just, it's junk. I mean, it's garbage. And again, none of them see fit to bring up things like healthcare, education. Maybe we shouldn't have billionaires anymore, things like that. What else did I want to say about that? Well, all right. So there's another phrase that FDR uses here. And so I can get to the transcript of it, because it's a worthwhile phrase. But he says that necessitous men are not free men. He says it somewhere. Maybe it's not here. Well, he yeah, he does say it. Necessitous men are not free men. We have come to a clear realization fact that true freedom cannot exist without economic security and independence. And that phrase is very similar to a phrase, again, by Marx, who says that the realm of freedom begins when the realm of necessity is left behind. And what they're basically saying, both FDR and Marx, although they have different politics, obviously, is that you can't really be free when the basic sort of struggle over basic needs goes on, when you have to worry about food and shelter and things like that, and literally have to struggle to obtain these things, then you're not really free. And I think it's a very interesting standard to bring forward, because if you were to take that standard very, very, very seriously, then that basically means that probably 90% of Americans, if not 99%, are not really free. So much for the land of the free and things like that. It's something that we tend to take for granted, I think. And maybe you have a different standard, that's fine. But if you were to use this standard for freedom, because 90% of people, at least, do have to struggle to obtain food and shelter and things like that, then you're not really free. And then only when those basic needs are taken care of can you really then sort of act as a free person. I think that's a good place to leave things. Again, I'd love to make fun of the Washington Post article because it's just so bad, but I'll wrap things up here. All right, so take care.